At the conclusion of this lecture, you will be able to define the role of the agent and give examples of such relationships. You will understand the formation of the agency relationship, be able to define the authority of the agent, and understand the potential liability of both principal and agent. Agency is the relationship that exists between a principal and his or her agent. The principal is the party who employs another person to act on his or her behalf, whereas the agent is the party who agrees to act on behalf of another. Any person with the capacity to contract can appoint an agent to act on his or her behalf. An agency relationship can only be created to accomplish a lawful purpose. It should be added that the agent can be given authority to further delegate responsibility to a third party, and in such circumstances, the principal has an obligation to perform the contract, whereas the third party must act in the best interest of the principal. Thus, in an agency, there is in effect two contracts. One made between the principal and the agent, from which the agent derives his authority to act for and on behalf of the principal, and another made between the principal and the third party, through the work of the agent. The agent has no personal rights or liabilities in relation to the contract of the principal. This means, if the principal becomes bankrupt under the contract on which the agent relationship was created, the agent will not be exposed to any liabilities arising from such bankruptcy. Employer and employee. A relationship that results when an employer hires an employee to perform some form of physical service. Principal and agent. An employer hires an employee that gives the employee authority to act and enter into contracts on his or her behalf. An example of such a relationship is of shareholders of a company, who are the principals and directors of a public limited company, who are the agents. Principal and independent contractor. A relationship that results when a person or business that is not an employee is employed by a principal to perform a certain task on his or her behalf. Express agency. This is an agency that occurs when a principal and an agent expressly agree to enter into an agency agreement with each other. The authority of the agent is limited, and in order to bind a principal, any contract entered into must be within the limits of the authority extended to the agent. If the agent contracts outside of his or her express authority, then they will be liable to the principal and to any third party affected. For example, an individual director of a company may be given the express power by the board of directors to enter into a specific contract on behalf of the company. In such circumstances, the company would be bound by the subsequent contract, but the director would have no power to bind the company in other contracts. Implied agency. The law can infer the creation of an agency by implication, when a person by his words or conduct acts as if he has such authority, and the principal acknowledges that he was entitled to act accordingly. Implied authority is not specifically mentioned by contract, but assumed or implied by the nature of the relationship. It is presumed to be given to an agent if that authority is necessary to perform the duties or responsibilities otherwise assigned to the agent or representative. For example, where one person allows another person to order goods on his behalf and habitually pays for them, an agency may be implied. In such a case, he will be bound by the contracts, as if he has expressly authorized them. See the case of Chan Yin T versus William Jacks and Company for a practical example of this. Apparent agency. This type of authority, which is an aspect of agency by estoppel, can arise in two distinct ways. Where a person makes a representation to third parties that a particular person has the authority to act as their agent without actually appointing them as their agent. In such a case, the person making the representation is bound by the actions of the ostensible apparent agent. The principal is also liable for the actions of the agent where they are aware that the agent claims to be their agent and yet does nothing to correct that impression. Where a principal has previously represented to a third party that an agent has the authority to act on their behalf. Even if the principal has subsequently revoked the agent's authority, they may still be liable for the actions of the former agent, unless they have informed third parties who have previously dealt with the agent about the new situation. See the case of Willis Faber and Company Limited versus Joyce. Agency by ratification. This is an agency that occurs when a person misrepresents him or herself as another's agent, when in fact he or she is not, and the purported principal ratifies the agency. An agency may be terminated by the following acts of the parties: mutual agreement, lapse of time, purpose achieved, occurrence of a specified event. An agency is terminated by operation of law if there is death of the principal or agent, insanity of the principal or agent, bankruptcy of the principal, impossibility of performance, change in circumstances, war between the principal's and agent's countries. In conclusion, agency requires a principal and an agent. The principal employs the agent. The agent acts on behalf of the principal. The agent must act strictly in accordance with the principal's instructions, or else he or she exposes themselves to liability. The agent can bind the principal to a third party. Agency can be created by express agency, implied agency, apparent agency, and agency of ratification.